Good morning, Ms. Real Schmidt. It's good to see you here today. Welcome, and when you are comfortable, you may begin with your opening comments.
Well, I want to begin, as I have in the past, by thanking you all for your dedication to the important work of this commission and getting to know me and all the other applicants in the process. So I was reviewing my remarks this morning, and by some miscalculation, I realized they were too long. As fate would have it, interestingly, I spilled my coffee at that exact moment, and 2 pages of my remarks were gone. Now, mind you, they are in 14-point font, which I still have to use the glasses for. 2 pages gone. So I would say rest assured, while perhaps not as brief as some of my previous remarks in this situation, they are briefer than I originally intended them to be. So I've been here a few times, and in the past I've talked to you all about the crooked path, the winding path that I've taken to this point, the varied practices that I've engaged in, the variety of places I've been, and the variety of people I've known. I've talked about my expertise in legal research, analysis, and writing, particularly with respect to appellate brief writing and appellate advocacy. I've talked about my expertise in transactional law, teaching, and representing a governmental entity. When I was here in January, I shared with you my family history, the story of the strong women in my life that have made me dedicated to the work before me, disciplined reflection and study, fearlessness and tenacity, and finding value in each person that crosses my path. So that's where we've been, and I want you all to remember that because I don't have 20 minutes times 4 to talk about all that. But today I really want to talk to you about justice and the attributes of a good justice. In the context of judicial decision-making, justice means impartially and consistently applying the law to give folks a fair shake. There are 3 essential attributes of a good justice that I want to talk about today and how I will bring those attributes to this court and strengthen it. First, a good justice is a practical scholar. I view a scholar as someone who has an intellectual curiosity, someone who is ready to take the deep dive into the difficult questions posed to this court and is capable of taking that deep dive. A scholar answers questions posed by following a body of principles and practices, a consistent analytical framework. In some respects, a scholar is an academic, but that's where we come to the practical part, if all of you have run into some academics in your life. To be practical and not just academic, a scholar on the court has to get to the heart of the issues, see them clearly, and communicate both complex and simple analyses in a straightforward and understandable way. The ability to take the deep dive, apply a consistent analytical framework, separate the wheat from the chaff, and communicate in a straightforward way ensures a fair and objective application of the law. I would bring that to this court. Second, a good justice sets aside internal biases in favor of the administration of justice. I've met many folks along my winding path, and I know that first impressions are often fueled by internal and implicit biases, so they should not be your last impression. My wonderful husband is a case in point. He's a librarian, right? Those shy, quiet, timid fellows who avoid adventure? Well, maybe not so much. And I'm really glad I gave him a chance to disprove my initial assumptions and biases. I've done a little bit of research on internal biases and how important it is to set those biases aside to come to an objective evaluation of my clients' cases. I'm a better lawyer for recognizing my implicit biases and the implicit biases of my clients and setting them aside and arriving at an objective evaluation of the strengths and weaknesses of my client in his or her case. I understand the tension between those internal biases and the administration of justice, and I choose justice. Finally, to be a good justice, You have to understand that justice goes beyond the courtroom and act on that understanding. I gave you a definition of justice that focuses on ensuring that folks receive fair treatment in the courtroom. However, justice can be administered outside of the courtroom. Representing Medicaid, I work on a variety of things outside the courtroom. I work with folks at Medicaid to implement procedures and processes, to write rules and draft legislation. I work with counsel for healthcare providers to help them find solutions to their problems. All of these are important to ensuring that folks get a fair shake, but it's outside the context of the courtroom. And sometimes I have individual situations that I can't resolve favorably for an individual in the courtroom, but I can look beyond it. Not long ago, I had a case where the Department of Human Services determined that an individual who had received payments to cover child care as a part of the Promise Jobs program was going to have to pay just shy of $2,000 because she hadn't properly documented her employment. $2,000 for someone who's struggling to be employed. She appealed in an administrative appeal process and she lost. She appealed from that decision in a judicial review action to the district court, and that's when it landed on my desk. She didn't timely file her request for judicial review, so I was charged in the representation of my client to file a motion to dismiss. I filed the motion to dismiss, but I looked at the file and I could see that this person had been very abrasive to folks in the department. And I also could see that her position was that she had been working. She just had not produced the documentation for it. Hearing was set on the motion to dismiss. I got there about 10 or 15 minutes early, and she was outside with a couple of children in tow. And so I sat down next to her, and at first she was abrasive, really, really abrasive. But as I sat and I listened and continued to listen and give her sort of that neutral feedback, she realized that I was really going to listen to her. And so she told me her story. And her story was, I was working, I have the documentation, I just didn't produce it. And then she asked me, can you withdraw your motion to dismiss? I said, no, I can't do that. But I told her about a process in the department called an exception to policy, where even if you don't comply with the rules, in her case submitting documentation, the department might waive the repayment obligation. So she took all that information in, and we went in, and the court granted my motion to dismiss, and before we left, I reminded her. Well, I've talked a lot about Medicaid, so you might guess Promise Jobs is not my normal area of law. And I got back to the office, and I began looking for the folks who might decide this exception to policy to get a feel for it. And I found them. And I explained the situation, and they told me they would not grant an exception to policy. Strike two, right? But interestingly, they told me if she would just go back to the maintenance worker she had worked with initially in the department and submit that documentation, they would withdraw the repayment obligation. So I asked them, when you deny her exception to policy, can you write in that letter in really plain terms, in a way that she can understand what she needs to do? And they did. They did a really good job. And she did submit the documentation, and the overpayment finding was withdrawn. Ensuring that folks get a fair shake sometimes means ensuring that justice happens outside the courtroom. Whether it's working to make the courts more accessible to everyday citizens, working to create and support problem-solving courts like the drug courts, mental health courts, and the like, improving digital capabilities of the courts, or just listening to someone and helping them find a different path to resolving their problems. I pledge to you that I will administer justice in the courtroom by impartially and consistently applying the law to give folks a fair shake. But I also pledge that I will look for opportunities to do justice beyond the courtroom. Therefore, I respectfully request that you nominate me to the governor to become a justice on the Iowa Supreme Court. I'm happy to take your questions.
Thank you. And we do have questions, and we will begin with Ms. Stanger.
Thank you. Good morning. Thank you for your application. I actually don't have any questions today.
Ms. Pearson?
I will just say thank you as well, and I do not have any questions.
I feel like a broken record, but yes, thank you for your application. I don't have anything further.
Mr. Hoytink.
I feel like a broken record, too. I don't have any questions. Thank you. It's good to see you again.
Thank you.
Ms. O'Brien.
Thank you. Ms. Schmidt, could you tell us how your philosophy of prosecution, if that's the right word, has evolved during your time on this Medicaid reimbursement assignment that you've had?
So I think, Commissioner O'Brien, that when I first came to Medicaid, I'd been an academic for quite a while, and I hadn't been in the real world of practice for about a little over a decade. So I wasn't ready for a little bit of the give and take and the contentiousness, and I think at that time I was more inclined to operate on a bias, and I was more inclined to see only my client's point of view. And it has been a very thoughtful time for me in the last 5 years when I've come to see that to be better represent my client, first of all, I have to understand the views of other folks on the other side. But it's also helped me in certain times come to a better solution than I might have had I continued to see it as oppositional as opposed to we're working together to make the Medicaid program better to support our vulnerable citizens.
Mr. Horbach.
Thank you for your application.
Thank you.
This morning, the Chief Justice welcomed us, and she said, "This is the 15th time I stand in front of a commission." And I go, here you are, by title, the most successful member of the court system in Iowa, and you were in front of the commission. This one was casual, of course, but must have been 14 times. And that showed me a lot about fortitude, and so I want you to describe your fortitude.
I think that's a great question. I think a lot of my fortitude comes from being flexible. A lot of you know that my path here essentially followed the career path of my former husband, and I think it's fortitude when you're able to walk into any situation, be confident enough, and practice the law that's before you. I think that takes a lot of fortitude. I think when you come to a point where you are then raising 3 children as a single mom later, when they're teenagers, that takes a lot of fortitude. I think that there's a lot of fortitude in what I'm doing now because it has required me to be so thoughtful about what it means to support the program, not just what it means about to take a position. So I think those are some of my ideas about fortitude and how I've exhibited it.
Thank you.
Thank you. Mr. Spies.
Well, to follow up on the last question, I mean, your application and the people who have spoken on your behalf attest to your persistence and your fortitude. And I've always been captivated by your experience in legal writing. And I thought about you in reading a book review about the power of the United States Supreme Court. I'm going to read you a quote and ask you to comment on it. "Those who read court opinions expect them to be coherent and understandable, and when they are not, the court might suffer. The rule of law supposes clarity. So when justices write unclear opinions, they fail to fulfill one of their key obligations. By writing clear opinions, they can maintain and perhaps even improve the court's reputation." Do you think you have the aptitudes that could increase the clarity of Supreme Court opinions and the reputation of the court?
I certainly do. I think that in my teaching life, I reviewed over 250 appellate briefs, giving feedback on each one, comments along the side of the page, and reviewed over 1,000 memos. Teaching other people how to do something certainly improves your own ability. It's what I think they call in academics, and I have to go back and check, but I think it's cognitive learning, where you learn about how you learn. And by doing that, you become stronger than you ever could be where you just learn it sort of by trial and error. So I think I bring a great aptitude to the court in writing clear opinions, and I agree it's so important to the longevity of our common law.
Thanks.
Ms. Law?
Thank you for your application. We had an applicant this morning who listed why she was the most qualified applicant for the court. And one of the things she told us was because she went to a high-ranked law school. You're a Drake graduate, as am I, and I think you have maybe a unique perspective on this issue, as you've taught at Drake and you've also been a visiting professor at a couple different law schools. You probably have a better knowledge base than most of us do about that. My question is how much importance, if any, should we put on the ranking by a magazine of a law school versus of candidates? And do you think that has any relevance on how good of an attorney someone is or how fit they would be to be a Supreme Court justice?
So, first of all, many of us went to law school before they had law school rankings, so we weren't making our decisions based on that. Second, in my experience, I think the folks that are at the top of their class at Drake are going to be at the top of the class anywhere. I also served on the applications committee, so I saw those applicants, and many of them could have gone to much higher ranked schools, but they chose, I think, wisely to take the full ride or a really good scholarship to get a good legal education. I don't think being first in your class or being at a higher ranked law school is what makes you the best at your job. And I think you're going to find some people who are more suited to certain jobs regardless of where they rank. So no, I would disagree with that. Not that I would undermine that that's valuable. My daughter, who went to the University of Minnesota, might be upset with me if I don't recognize the value of her highly ranked education. But I think in the long term, it doesn't make a real difference in the worth of your work.
Thank you.
Mr. Bevel?
Nothing.
Mr. Goodman? Mr. Bloom? I've done that twice now. Mr. Bloom?
If a future governor were to ask you to serve as their counsel, legal counsel, and you understood that if you did serve in that role, you would be perceived as political and therefore disqualified in some people's mind from applying for state court openings, what would you do?
I think it would depend on what I wanted to do most. And I think also the chances of getting to do what I wanted to do most. So I think that's a good hypothetical that needs a lot of filling in for me to directly answer. But I think it would be difficult to turn down an opportunity like that. But I certainly wouldn't perceive that I ought to also apply for this position at the same time. You might give it a little bit of a rest. But I don't see that as being as being a wall to someone in the future when they're in a different position applying for this court.
Okay, thank you.
Mr. Goodman?
I was going to say that Mr. Goodman stole my question, but I want to capitalize on what Mr. Bloom asked you about. We have received some letters that have named some lawyers that have applied for this position, claiming that they are in state of Iowa positions as counsel, and they are not suited to serve on the Supreme Court because that's an inherent conflict. What I would like to know is for you or any other lawyer that represents the state in any capacity, how would you ethically execute your duties, and in what cases and for how long would you recuse yourself or otherwise address whatever ethical component there is in the problem I've described for any state lawyer?
I appreciate that question, and I really wish I would have read the rules of judicial conduct before I came today, because I'm sure a lot of that would help me make my decision, and I would certainly consult that. So anything I have to say today, I want to say that it's without having consulted what I think would be the authority. But I think for a certain amount of time, there are certain matters I would have to recuse myself on that I've been directly involved in. I think on the others, just as when you practice in a law firm, I think you'd have to determine how close you were to that, where the wall was, and where your interests lie. I don't think I would be recused forever from Medicaid cases, and that would be a shame because I think I could bring some insight into the law in that area. I wish I could answer you in greater detail, Commissioner Goodman, but I really, really want to have my rules in front of me before I do that.
Sure. I just want to ask this question. It would be for some period of time, and it would not necessarily preclude you from hearing a State of Iowa Department of Transportation claim or something that has absolutely nothing to do with Medicaid. Is that fair? Or
That is fair.
Okay.
That's fair.
Thank you.
Thank you. Well, we are out of time. The time goes very quickly, but thank you for being here and taking time to answer our questions. We wish you well.
Thank you.